Good morning. Because I have to rush to Chengalpet before 9. I left early. I could not telecast in the morning. But this judgment which I am going to share, in which Supreme Court judgments were discussed about challenging the legislative proceedings and proceedings of the Speaker. I just share the judgment for the politically aspiring advocates who should at least have some basic knowledge how the question of balancing the three pillars of the democracy: executive, legislature, uh, and judiciary. So this was what actually happened. A letter was addressed in the Meghalaya Legislative Assembly to the Speaker, and the Speaker disallowed his application under Rule 130A of the Rules of Procedure and Conduct of Business of the Legislature. So when he gave a letter challenging about some improper distribution of power corporation limited, but the denial was that they say because some other references are there, and a public accounts committee is about to consider this issue. So therefore they disallowed the motion. But he filed a writ petition, and the writ petition, the division bench of Meghalaya, AR 2025, 20, page 20, Meghalaya High Court, division bench, Albrecht Nongram versus Speaker Meghalaya Legislative Assembly. I discussed about few Supreme Court judgments where they said under Article 212 of the Constitution of India, the principle of separation of power of three organs of the government, executive and legislative judiciary, and complete autonomy of the legislature in conduct of proceedings, and so on so terms. They have also discussed by narrating 212 of the Constitution of India. They have discussed about Ramadas Atwale, Union of India, AR 2010, SC 1310, and also other Supreme Court judgment wherein they have discussed about AR 2023 SC 1249, wherein State of Punjab, Principal Secretary to the Governor of India, they have, if suppose deliberately something was denied, then the High Court can simply said when the entire proceedings is unconstitutional, illegal, beyond the competence of legislature, then they worded it that legislators step out of the protection of Article 212, and the High Court in exercise of writ jurisdiction has the power to adjudge null and void the proceedings as well as all the illegal procedure followed to implement it. But here in this case, they have rejected the claim of the writ petitioner, and writ petition was disposed of. Therefore, your duty is to go through the entirety of the judgment so as to competent yourself while you are addressing your political leaders, or at least you can advise your political leader, exhibiting your competency in the legal knowledge. Best wishes.